right, sir, you Jay Stovall?
Yes, Your Honor.
And this is cause number 25 DCCR 1872. Mr. Stovall is charged with violating a protective order. And Mr. Gertz has filed a motion to quash the indictment. I've obviously reviewed that motion. Mr. Coleman has filed a response, or a reply to that motion, and we're here today on that. I've done obviously some of my own research as well.
Filed a reply to Mr.
A reply to the reply.
Agent.
Oh, just a second, I didn't see that come through.
It's short. It will take you 2 seconds to review it, I would suspect. Hyperbolically, of course. Not pay attention.
So 1338 has been repealed.
That's my understanding, Judge.
Yeah,
I think
Judge,
the applicable statute is 13A.203.
I think that's correct. If you actually read the language of my original motion, I say that it used to be this, it's now been changed to this, and they mean exactly the same thing. The reason I point that out, Judge, is that the legislature recently revisited venue on this statute and chose not to add where the complainant resides as one of the options. And so that's why I was pointing out what the old statute said and what the new statute says. So
So the new statute is what?
it reads almost identical. It's
13.
13A.203.
Thank you. Okay. Getting there, just give me a second. I want to look at everything real quick. The indictment in the style is 25072, but it should be 25071, I believe. Well, I mean, that's not, it's violation of a protective order, correct?
it has to be multiple to be a felony. And that's
Well,
what gets us to 7.2, I believe.
7.2 is repeated violation of certain court orders or conditions. 7.1 is violation of a protective order.
Right. I think they may have kind of pled it as hybrid, but they're talking about 0.2.
I would concede and agree that it should be 02, Judge.
Okay, so it says 0.2. That's correct then. All right. Okay. So with regard then to the new 13A.203, this is not a protective order.
It is a protective order,
But
Judge.
the indictment alleges violating a condition of a bond.
I will again concede error on the state's part, and that could be remedied, as I put in my reply, simply by amending the indictment.
Well, I think that probably should have been done because I
didn't want to amend it until I got the court's ruling on the other issue, the issue of venue.
But that matters. So, okay, so let's do it this way. If it's a protective order specifically, then 13A.203 appears to be specifically on point. So what's the state's position with regard to that? Because it says specifically what the venue is.
Well, my understanding of 13A.203 is that either it can be prosecuted where the protective order was issued or where the offense, quote unquote, was committed. Certainly, we're not seeking to prosecute it in Travis County where it was issued. The fallback would be where the offense is committed. And since statute is silent in the regard as to whether or not it can be venues proper where the complainant resides, I cited cases that I thought were instructive for the court, Your Honor. In other words, an issue here is the offending communication that was sent, electronic communication allegedly sent by this defendant that violated the protective order. And I think the cases that speak to either obscene or harassing communication that we've cited in my reply, it speaks to venue. In fact, the 14th Court of Houston that cites a Court of Criminal Appeals opinion, it specifically says, with regard to an obscene communication, the venue is proper where the applicant or the victim resides. And as it relates to an obscene telephone communication, that's in the in appellate court out of Austin, 1991, that's cited in my reply. It says, with regard to that telephone communication, that venue is proper where the victim resides as well. So again, in construing 13A.203, I think those instances are they're instructive for the court to interpret that statute in the absence of more specific language that could have been or should have been provided by the legislature. And I'll just end with this, Judge. To rule otherwise would render, in my opinion, an absurd result in that a victim would have to travel to wherever this defendant may have made the offending communication, be it on a laptop somewhere in another part of the state, or maybe even outside of the state, Judge. So I just think that in this day and age of cell phones and mobile digital devices, that it's more appropriate for the venue to reside where the defendant received the communication.
Mr. Gertz?
Judge, multiple things that Mr. Coleman said I think are incorrect.
The discussion quickly shifted toward the legal authority being relied upon by the defense. One side pointed out that the cited case dated back to 1993, which came from a very different era long before social media became part of everyday life and even before mobile phones were widely used. That raised concerns about whether such an older ruling could fully address the realities of modern communication and online interactions. The court was encouraged to look beyond the age of the case and focus on how its reasoning applied today. Attention then turned to the facts behind that decision. A closer review revealed that the individual involved had been convicted for several forms of repeated and troubling communications rather than a single isolated act. Because of that, the court considered whether the circumstances were truly comparable to the matter now under review. The judge emphasized the importance of examining the specific details rather than relying only on broad references to past rulings. The conversation then moved to the wording of the statute itself. After reviewing the language, the court noted that the law speaks about where an offense is committed rather than where a defendant happens to be located. That distinction became a central issue because the statute does not directly tie venue to the physical location of either party. Instead, the focus remained on identifying the place where the alleged conduct legally occurred. As the analysis continued, the judge explained that the key research question was not where one person was standing or living at a particular moment. The real issue was determining what the law means when it refers to an offense being committed. Since the statute does not specifically mention the location of the accused or the alleged victim, the court appeared cautious about drawing automatic conclusions from language that was not expressly written into the law. That careful approach kept the discussion centered on statutory interpret. The discussion quickly shifted toward the legal authority being relied upon by the defense. One side pointed out that the cited case dated back to 1993, which came from a very different era long before social media became part of everyday life and even before mobile phones were widely used. That raised concerns about whether such an older ruling could fully address the realities of modern communication and online interactions. The court was encouraged to look beyond the age of the case and focus on how its reasoning applied today. Attention then turned to the facts behind that decision. A closer review revealed that the individual involved had been convicted for several forms of repeated and troubling communications rather than a single isolated act. Because of that, the court considered whether the circumstances were truly comparable to the matter now under review. The judge emphasized the importance of examining the specific details rather than relying only on broad references to past rulings. The conversation then moved to the wording of the statute itself. After reviewing the language, the court noted that the law speaks about where an offense is committed rather than where a defendant happens to be located. That distinction became a central issue because the statute does not directly tie venue to the physical location of either party. Instead, the focus remained on identifying the place where the alleged conduct legally occurred. The court also reviewed additional legal precedent, including a case from 2003 that addressed venue questions. That decision stated that venue can be proper when there are substantial connections between the alleged conduct and the county bringing the prosecution. Those connections may involve the defendant, the actions in question, the alleged victim, or any benefit that resulted from the alleged offense. The judge noted that numerous decisions have followed similar reasoning over the years, which strengthened the relevance of that legal.
The one that I was reading from is a 2023 case that cites that Solis case from 2003. And so I think the same result that in these types of cases, because of electronic communication, to have to say, we don't know for certain and can't know for certain where either of them were when they were on their phone or whatever they were on doing, either sending or receiving. And so I don't think it should be limited. I think it is a jury question.
May I be heard on that though, Judge?
Sure.
The default position, and the code gives you a default position. The default position is if it cannot be readily determined by the facts, then it goes back to the three other options, which are where he was arrested, which was Travis County, where he lives, which is Travis County. I mean, Mr. Coleman used the word gravamen of the gravamen of the venue statute is about him, not about the complainant. And
But
so
if
you
it
see
can't be determined from the facts, I'm not doing, that's a jury question, is to determine the facts. I don't think that me determining that is necessarily, I think that would put me in a position where I would put myself in the position of the jury in something that's not necessarily as clear as some indictments where a quash would be potentially granted.
May then I be heard just on one other issue?
Yes, sir.
Mr. Coleman raised. So he said that would render an absurd result if we followed the venue statute narrowly. I would suggest to you that it actually renders an absurd result if we follow it the way the state is proposing. And here's why. What it would allow any complainant to do is go to a really favorable county where the police like that person and the judge likes that person and whatever, and then open their Facebook and say, oh, man, I read it in Jasper County and everybody likes me in Jasper County. Let's bring him who's never been to Jasper County.
Well, is that
here.
the allegation about the complaining witness in this case? Did she come here and do that?
I think
Is
she
that what the
moved
allegation?
home to her family's house, but he's never lived here. He's not been a resident here.
But she has that tie here. She didn't just show up.
I understand, but he's talking about it rendering an absurd result, and I'm saying it's the exact opposite. The venue statute is about whether he has to be hailed in front of a jury for which he has not made his own sufficient ties. It's not about the complainant's ties.
Except that it is sometimes, specifically. No, but the Court of Criminal Appeals has found now several times, Court of Appeals cases and Court of Criminal Appeals cases, that venue is proper in a multitude of places. And so based on that, I think this one is not something that is as black and white as I think you're making it sound, or your perception is. I think that it would create the potential for someone to be able to say, I wasn't there when I said, I mean, everything is, so the movement of everyone with computers and phones, I don't think it should be restricted in this case based on what I know and not what I know about the case, what the indictment alleges with regard to the communications being received by the complaining witness in Jefferson County. and that the case law specifically says that venue could be appropriate in a county where the victim is where the fruits of the crime were or where the conduct affected someone in that jurisdiction. So based on that, I'm going to deny the motion to quash. We'll reset the case for an announcement. Go ahead.
I'll get the indictment amended.
Okay.
To reflect protective order versus bond.
That's fine. We won't have any objection to that.
Okay.
Judge, as it should be obvious from all the filings, my client lives in Austin. And so what I'd ask, I don't anticipate there's going to be an offer from Mr. Coleman that my client's going to accept. I don't know if you want to do one announcement and then we can put it on the trial docket at that point.
Yeah, I mean, unless y'all have already negotiated and received everything and gotten an offer, I'm just going to do a normal reset and you can reject any offer at that time if there's a rejection, and then we'll get it set for trial after that.
Okay.
All right.
Thank you, Judge.
Pretty good.
Thanks, Judge.
Good morning. Are you Felicia Freddy? Speak up loud
Speak
and
up
clear
a
so
little.
I can hear you and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddie, in clause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that.
We got it reduced down, is my recollection.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a class A or B?
Eluding is typically B, isn't it?
I'm not sure, Judge.
If I had a second, Judge, I could.
Here, I'll look at the
Mr.
end.
Smith says B.
The papers. A. Of that motion, second amendment. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually pled to the lesser included.
Any objection to that?
I don't mind the court amending that motion, Judge. It's probably not what you asked me. I don't object. How about that?
That's good, thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, a class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges
Now.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense. So 2, it's resisting arrest, search, or transport, and a
Yes.
silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner, especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true?
True.
All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
No.
So stop and talk to probation on your way out here of the court.
The discussion quickly shifted toward the legal authority being relied upon by the defense. One side pointed out that the cited case dated back to 1993, which came from a very different era long before social media became part of everyday life, and even before mobile phones were widely used. That raised concerns about whether such an older ruling could fully address the realities of modern communication and online interactions. The court was encouraged to look beyond the age of the case and focus on how its reasoning applied today. Attention then turned to the facts behind that decision. A closer review revealed that the individual involved had been convicted for several forms of repeated and troubling communications rather than a single isolated act. Because of that, the court considered whether the circumstances were truly comparable to the matter now under review. The judge emphasized the importance of examining the specific details rather than relying only on broad references to past rulings. The conversation then moved to the wording of the statute itself. After reviewing the language, the court noted that the law speaks about where an offense is committed rather than where a defendant happens to be located. That distinction became a central issue because the statute does not directly tie venue to the physical location of either party. Instead, the focus remained on identifying the place where the alleged conduct legally occurred. The court wrapped up the matter by scheduling a future sentencing hearing and making it clear that any information considered important should be shared through defense counsel before that date arrives. The judge emphasized that all relevant details could be presented during the upcoming hearing so the court would have a complete picture before making a final decision. With those instructions given, the proceeding came to a close and the defendant was released from a courtroom. The brief exchange marked the end of one phase of the CEA. The judge then outlined the allegations, stating that the defendant faced a state jail felony charge involving a government record connected to an incident from August of 2024. After the charge was placed on the record, the defendant was asked to enter a plea. The courtroom remained focused as the judge carefully worked through each required step to ensure the process followed legal standards. Every response became part of the official record of the proceeding. Next, the court sought confirmation that the plea was being entered voluntarily and without pressure from any outside source. The judge carefully asked whether the defendant was making the decision freely and of his own choice. This portion of the hearing is designed to ensure the defendants fully understand the consequences of their actions before a plea is accepted. The defendant confirmed his decision and indicated his intention to move forward. The judge also asked whether the plea was being entered because the defendant accepted responsibility for the conduct described in the charge. This exchange is a routine but important safeguard that helps establish the factual basis for the plea. By answering directly, the defendant acknowledged the allegation before the court. The judge continued methodically through the required questions to make certain every legal requirement was satisfied. Attention then turned to a collection of documents displayed on a courtroom tablet. The judge explained that the paperwork had been submitted as evidence and contained the defendant's signature. Before accepting those materials, the court wanted to confirm that the defendant had reviewed them with his attorney and understood their contents. The defendant stated that he had gone over the documents and understood what they contained. That confirmation helped complete another important step in the plea process and move the case closer to resolution.
The case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Do y'all have the discovery certification?
Sign it now, please.
You'll need to have a seat after you sign that. Have a seat here in the courtroom. Probation's in that desk right there behind you, and she'll call you up when she's ready to go over your paperwork. You can go ahead and have a seat,
Thank
sir.
you.
Just watch for her to call your name.
Yes, sir.
Thank you, Your Honor.
Thank you. That's a big issue on that other one. Good morning. You are Alexandria DeLeon. And this is cause number 26 DCCR 0143. Ms. DeLeon is charged with assault on a peace officer. And what is the announcement?
Your Honor, we'd like to reset. Ms. DeLeon has some contractual obligations. She still needs to meet with my office. We've received everything from the district attorney's office. I've been in contact with the district attorney. I think this is going to be a case that we're able to resolve. We'd like to come back in August if that's possible, Your Honor.
We'll just do a normal reset.
Perfect.
Which is about 30 days, and then we'll see where we are at that point. I know you were just hired last month, so
Yes, ma'am.
I mean, I'll give you some leeway, but let's see where we get in 30 days. Miss Miss DeLeon, make sure you stay in touch with Mr. Nick, visit with him about your case, take care of everything you need to. We'll see where we are at that next court date.
Thank you,
All right,
Judge.
here we go. Good morning. Are you Edgar Castillo?
Good morning. Yes, ma'am.
And Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Castillo, in clause number 25, DCCR 1052, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from March 23rd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
The hearing continued as the court reviewed the plea agreement that had been reached between the parties. Under the proposed arrangement, the defendant would receive 2 years of deferred probation along with a financial penalty. The judge carefully explained that probation comes with a series of rules and responsibilities that must be followed throughout the supervision period. The defendant confirmed that this matched his understanding of the agreement and acknowledged the obligations that would come with it. The court then addressed an important legal warning that is routinely given in criminal cases. The judge explained that for individuals who are not citizens of the United States, a guilty plea could carry serious immigration consequences under federal law. Those consequences may affect a person's ability to remain in the country or seek future legal status. By placing that warning on the record, the court ensured that the defendant was aware of the possible effects beyond the criminal case itself. This step serves as an important safeguard during the plea process. Attention then shifted to the evidence submitted by the prosecution. The state formally offered its first exhibit, and the court accepted it into the record without objection. After that, the judge asked whether there was any indication that the defendant lacked the ability to understand the proceedings. Defense counsel responded that there were no concerns regarding competency. That exchange cleared the way for the court to continue with its findings. After reviewing the information before the court, the judge stated that the guilty plea had been entered knowingly and voluntarily. The court further found that the defendant was mentally competent and understood both the nature of the charge and the consequences associated with the plea. Based on the evidence presented, the judge concluded there was sufficient support for a finding of guilt. These findings represented a significant step forward in the CEA. Even with those findings in place, the judge chose not to impose a sentence immediately. Instead, the case was postponed so that a pre-sentence investigation could be completed by the probation department. The purpose of that report is to provide additional background information about the defendant and the circumstances of the case. By gathering more details, the court would be better positioned to determine an appropriate outcome at a later hearing. The judge emphasized that the report would play an important role in the final sentencing review. Before ending the proceeding, the defendant was instructed to meet with a probation officer before leaving the courthouse. The judge pointed out where the officer was located and made it clear that the meeting needed to take place that day. Once those directions were given, the court concluded the matter and scheduled the defendant to return for sentencing at a future date. With that case temporarily paused, the courtroom quickly transitioned to the next person on the docket. The judge greeted a new defendant and began the process by confirming his identity and addressing the formal reading of the indictment before moving ahead with the next hearing.